Want to?
Yeah, thank you so much for giving me the opportunity to try and go through what I would consider as Ubuntu in terms of a new constitutional quest, perhaps for Uganda as a country. So I will try as much as possible to go as much uh, detailed analysis, particularly in terms of the references that I'll use. So all those that you see here are things that I'm likely to employ in terms of emphasizing certain aspects in terms of what Ubuntu would actually stand for. And I know that Ubuntu could actually connote different things, not things in a general perspective, but perhaps the language in which you use the word Ubuntu could actually be reflected in different dialects. But in doing that, I'm reminded of a phrase by William Shakespeare, which he alluded, I think, in Romeo and Juliet. What is it that we call a rose can still smell sweet even if called any other name. So it tells you that this word Ubuntu, although it may be found in different dialects, but the emphasis is the same. The emphasis is the same in the context of what it stands for. That is where I'm coming from, and I think we mentioned that somewhere here. I could take time to read for you that particular aspect, that we call a rose can still smell sweet, even if called any other name, because those are some of my intros, because they give us the basis under which we should also contextualize or analyze the concept of Ubuntu. But it is something that is important. So I will refer fair enough to some of the things, but we shall have a discussion in terms of what it says. But also, particularly in the context of how Ubuntu has been misconstrued, perhaps even from the beginning, by the colonial legacy that was imputed upon us. And I have several quotes, but one that rubs off extensively is the one by Lord Macaulay. His address to the British Parliament on 2nd February 1835, where he said, "I have traveled the length and the breadth of Africa. I have not seen one person who is a beggar, who is a thief. Such wealth have I seen in his country, such high moral values, people of such caliber, that I do not think we could ever conquer this country unless we break the very backbone of this nation, which is her spiritual and cultural heritage. And therefore, I propose that we replace her old and ancient education system, her culture, for if the African thinks that what they have is not good, then they would argue that English is good and greater than their own. They will lose their self-esteem, their native culture, and they will become what we want them to be, a truly dominated nation." And that is something that probably should send chills within your bones if you are, an African lover in the context of jurisprudence for perhaps African, call them Pan-Africanists of sorts. So we have those things that are laying for us the background. I will talk to probably bring a number of concepts in terms of different scholars as well, who have written extensively in terms of that. So that is fundamentally one thing that I may want to point out from the word go. But for purposes of this argument, in terms of the discussion that we have today, Ubuntu is expressed particularly in Uganda's constitution, although it can be reflected, as I said, in different terminologies or different cultures or people. Talk about the Baganda, Basoga, Banjara, the Northerns, the Cholis and likes. It's fundamentally embedded, by the way, in the 1995 constitution, but jurisprudentially unactivated. It's not activated due to colonial positivist legal architecture, and that's the point I'm trying to say. So you just had me read a quote in terms of what those guys were planning for us in the context of changing our ideology or thoughts into theirs, and in doing that you abandon what you probably organically made in terms of survival, and then you adapt something. You're probably they graft with a different thing. So we are saying that positive legal architecture that enabled them, or even our jurisdictions, in terms of following their ideologies, is a problem. And I will argue some of those aspects. So the dissertation in terms of my analysis today demonstrates that historical analysis in terms of the Ubuntu's cross-ethnic roots, yes, but also the constitutional analysis in terms of the Ubuntu resonant provisions, and then a typological analysis, call it a typological, forgive the typo, in terms of the typological analysis of some substantive cases in terms of how they play out, and then of course comparative analysis in terms of Kenya, South Africa, Uganda, Rwanda, and then the aspect, the drumming of the constitutional dispensation in terms of expressing Ubuntu as a foundational value, recognizing Ubuntu-based justice and the mechanism, and training an Ubuntu-conscious judiciary perhaps, and reforming our legal education becomes constitutionally commanded and practically achievable if we do the following. And that is my argument in terms of the discussion that I'm having today. So I framed certain objectives in terms of that, but these are consonant in terms of some of the things that we find in this book, this particular one here, because it lays out certain facts and certain truths about what we need to do. So now one is to examining the aspect of the origin and the historical foundation of the perceptions of Ubuntu in Uganda, and how do we, where did it originate from? What are the historical narratives that are associated with it? And then how do we draw out the foundational perceptions of Ubuntu? How does it play out in the context of Uganda per se? And then in terms of another objective, in terms of examining the constitutional place of Ubuntu from 1995 to the present, how has the constitution perhaps played out the application of Ubuntu in terms of that? And then another would be in terms of examining the application of Ubuntu in Uganda's courts and legal system, particularly from 1995 to the present. And then fundamentally also examining the experience of Ubuntu. And then I, of course, make comparison with South Africa and other countries in that context. And then obviously drawing the conclusions that advance concrete recommendations in terms of Ubuntu's constitutional realization as far as Uganda is concerned. And of course that informs us that we shall have to look at the theoretical framework, because the theoretical framework then becomes the backbone under which your discussion is likely to flow. It is very extremely important for you to follow that theoretical framework, because now it gives you the basis under which you are now going to write. And by the way, the theoretical framework should actually run through almost every element, even in terms of the specific objectives that flow through your discussion in terms of the analysis of our work today. So primary framework in terms of a framework would be legal pluralism in terms of Griffins. Griffins made that proposition that law exists beyond the state, and that is something important. In the context of analyzing, we should be premised on the fact that we should analyze the law, but we should also understand the law, that the law should exist beyond the state, beyond that, that state authority in that context. And then so therefore, in terms of a lens, I would argue in terms of using Menz makes a serious proposition in terms of the moral theory. So I would argue in terms of the Ubuntu moral theory, which was propounded by Menz. And here he says that Ubuntu is a universal moral theory grounding dignity, equality, and also the community in that context. So it is a universal moral theory in terms of those fundamentals, in terms of dignity, equality, as far as the society should actually be organized. And then the second lens I would like to look at in the context of that would be a transformative constitutionalism. And this is propounded by Langa. Langa makes a very serious argument here, and he was one of those justices who presided over Ara versus Mukwanyane, the popular death case in South Africa. But what that laid fundamentals, by the way, in terms of the Ubuntu conceptualization of the law. So his argument is that constitutions must generate substantive moral change. If the constitution doesn't generate that, then we have a problem. So I'm premising my discussion in terms of that context, trying to understand that constitutions must generate substantive moral change in the context of how they are played out. And then as a lens, another third lens would be decolonization framework. And this is popular, but I choose to use the one of Dr. Kawumba. Dr. Kawumba Businje makes that proposition in terms of his argument of the black letter positivism, where he says colonial inheritance that excludes Ubuntu. It was fundamentally provided for with the colonial inception, with the order in council, with the repugnancy clause, and all the things that played out. There was an element, a deliberate element in terms of legal positivism to let what he argues as black letter positivism to filter out or to negate what could be construed as native in terms of African philosophy. So that those are the compositions that he tries to play out in terms of that. And then I would argue in terms of supplementally looking at the Dworkin interpretism also as a philosophical framework in terms of what he said. The law is looked at as an integrity, it should be substantive in integrity, and that is a big word, by the way, and the context of Goethe's restricted communitarianism. So all those will propound and inform the discussion that I'm having today in terms of the theoretical framework for you. And then I will argue in terms of fundamentally what would settle best for my discussion. What generally would settle best for my discussion would be in terms of Ubuntu's interpretive principle, in terms of what I would argue as UIP. And this will inform the doctrinal contribution that I will argue again at the end in terms of the discussion that we're having this evening. So in terms of the interpretive principle, I'll argue it in terms of levels. My first level would be interpretive obligation. Yes, courts must engage Ubuntu when interpreting constitutional provisions. Yes, especially under Article 126.1, which gives the mandate to adjudicate in conformity with the values, norms, and aspirations of the people. As we all know about that. And then I'll argue it in the context of level 2, which says the domain in terms of specific standards. And here I'm looking at Ubuntu establishing constitutional standards for sentencing, for restoration, not merely retributive in that context. And therefore, the aspect of succession also in terms of communal contribution of property, and they'll become relational, not merely individual, and the customary law aspect as well in terms of an evaluation, in terms of the Ubuntu grounded repugnancy standard that's as propounded by Dr. Kabumba in that aspect as well. And then I'll look at in terms of the context of rational remedies. Courts must fashion remedies that restore communal relationships, not merely award monetary compensation, because that was propounded by Justice Makoro in Dikolo versus Mokata, which he demonstrated with the public apology remedy in terms of that context. Excuse me. Yes, so now I will also go further in terms of the context of my next discussion in the context of establishing a purpose for the discussion tonight. My purpose basically would be premised on the fact that it is I'm creating a foundation in terms of the foundational challenge that how Ubuntu is being challenged in the context of its play out in our country. But these are all premised on foundational backgrounds in the context of the Uganda's constitutional order that suffers legitimacy, deficit because of its moral language is alienated from the lived values of the people. That is fundamentally important. And then the aspect of the black letter positivism, again, which I'll find myself talking about extremely because of looking at Dr. Kabumba's critique, becomes a colonial legal inheritance that actually systematically excludes Ubuntu from judicial reasoning. Yes, and then I will marry that together with Article 126.1 of the Constitution, which mandates people-centered adjudication. And this is a constitutional warrant for Ubuntu jurisprudence in the context of how and what should be done. And then I study the analysis in terms of the socio-legal methodology, socio-legal in the context that it becomes a doctrinal analysis with the substantive empirical field research across Uganda's principal ethnic communities, and I pray that I'll also talk about that at a certain time. So the fundamentals in terms of the key formulation from this particular aspect is the concept of I am because we are, therefore I am. That was propounded by Mbiti. When you look at African religions and philosophy, his book, it brings out that content well. And then Ubuntu is one of those things that you recognize when you see it. That was provided by Justice Makoro, if you remember. And these are fundamentals because they create the basis under which our discussion is going to take place. And then you look at Ubuntu as an African equity. Bennett said that. You want to look at what Bennett said in terms of that context. And then the aspect of the trap of black letter law in Uganda that was propounded by Dr. Kabumba in terms of what he argued in under public interest law that was way back in 2019. So those are fundamentals in terms of what informs our background of our study in terms of what is going ahead for our discussion. Then I'll look at other things in terms of, now I'm playing out what I would argue in terms of the breakdowns, in terms of the chapter breakdown, which would be the analysis of the origins in terms of the foundational perceptions of Ubuntu in Uganda. And the purpose here is to establish the theoretical, the historical and cross-ethnic foundations of Ubuntu in Uganda through empirical research and confirming Ubuntu's plan in terms of pan-Ugandan character, in terms of that aspect. So the key arguments here would be that Ubuntu is not a South African import. No, 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 no. It has a deep pre-colonial root in Uganda through Oricha, of course, and of communal governance and restorative dispute resolution. And it's a cross-ethnic, has a cross-ethnic convergence, if you like. Like I said, in Buganda and Busoga, you may want to call it Ubuntu Bulamu, and then Ubuntu in Banyachitara, and then Dano in the Luo, and then Ubuntu cognate values among the Iteso. So that is important as well. And then the concept of the transmission mechanism, the Oricha, in terms of Pius Rimu's term, he called it the Oricha, in terms of folklore, in terms of proverbs, in terms of fireside stories. All those tell us in terms of how the Ubuntu was playing out in the context of that African setup, if you like. And then the colonial suppression, we argue in terms of the repugnancy clause, the individualization of land tenure, for example, in terms of the Buganda Agreement, particularly the 1900 Buganda Agreement, and then the colonial court hierarchy that happened in terms of the 1902 Order in Council. So those are fundamentals, but also important in terms of grounding a discussion for us in terms of my analysis today. And then the two major population movements from 1000 to 1500 AD, which shaped Uganda's ethnic landscape. Ubuntu values predated and survived colonialism in the context of that as well. So for perhaps as an important aspect in terms of scholarism, I would like to look at John and Brooklyn. Brooklyn, who actually mapped Ubuntu's linguistic variants across sub-Saharan Africa. Yes, in terms of Bumuntu, in terms of Tanzania, for example, and then Bomoto in terms of the Congo, and then Jimuntu in terms of the Angola, establishing a shared African philosophical inheritance. So we are saying this thing is all of Africa, you know, for to use that word loosely. And then in terms of my next chapter, I would argue in terms of the contextualization of the constitutional place, the aspect of the constitutional place of Ubuntu in 1995 to the present, and how does that play out? In terms of the purpose, you could argue that it basically maps out the Ubuntu's presence and absence. Do we have Ubuntu, or is it absence? You know, within the 1995 Constitution, in terms of as a text, you know, and the court's formal engagement with these Ubuntu values. And this becomes extremely important. And in doing that, I would want to look at the 5 constitutional anchors. These are fundamentals, but very important, because you could call them substantive in nature, in the sense that you cannot talk about this without invoking them. So you would want to begin with the preamble, perhaps. The preamble creates that aspect of unity, peace, equality, democracy, freedom, social justice, and all this carries Ubuntu resonance in one way or the other. And then you want to look at the national objective, 3 particularly, where we're arguing that every effort shall actually be made to integrate all the people's Ubuntu communal pluralism, you know, in that context. And then the national objective 2024, which also states that the state shall actually recognize or preserve and even promote cultures of Uganda in terms of giving it a positive obligation for Ubuntu transmission. And then if you look at Article 37 as well, in terms of the cultural rights that are held to the community with others, in terms of Ubuntu communal constitutional identity, and then the aspect of Article 126.1, which provides for judicial power exercise in conformity with the values and norms and aspirations of the people, in terms of the Ubuntu mandate, perhaps in terms of that context. And then Article 43, in terms of rights limited by communal welfare, Ubuntu balance between individual freedom and even collective obligation in terms of that. So what then becomes the constitutional paradox in this aspect? The constitutional paradox is based on the fact that the 1995 Constitution contains significant Ubuntu consonant values, but does not expressly name them. That's where I'm coming from. Whereas it includes or it contains significant Ubuntu consonant values, it does not expressly name them. And I'll make a case for that in comparison with South Africa in terms of how it has played out even after today. So this creates what they call a latent presence and partial realization. Yes, real but incomplete. So constitutional space exists, yes, activation through judicial engagement and constitutional amendment therefore becomes a requirement. And that is fundamentally what we are arguing in terms of the dispensation this evening. Then if we go to the next chapter, that probably will be chapter 4. I would argue in terms of the application of Ubuntu, in terms of Uganda's code, fundamentally from 1995 to the present. And the purpose here will be that the empirical heart of my discussion is created on what they call a typological analysis. And I made a bearing or analysis in terms of about 45 cases, demonstrating how Ubuntu operates in a jurisprudential undercurrent in terms of Uganda's legal order. Yes? And now, for purposes of this typology, I actually broke it down in terms of what they call a 3-category typology. Yes? Category 1 would argue in terms of the explicit Ubuntu cases, those that explicitly invoked Ubuntu. Yes? So Ubuntu is named fundamentally as a jurisprudential warrant, You know, an anchor case would be things like Salvatore Abuki versus Attorney General, and particularly if you look at Justice Tabaro's foundational aspect of Ubuntu in terms of his judgment, but also in terms of Kanyamunyi versus Uganda, Justice Mubiru naming Matoput as an Ubuntu grounded aspect also creates that that special category of category number 1. And then you argue, and then I'll argue in terms of category number 2, where I would argue in terms of what they call the latent Ubuntu cases. Yes, we have it, but it is hidden within, where Ubuntu, Ubuntu outcomes without Ubuntu doctrine. There's the fact that we see, hey, wait a minute, it's Ubuntu, but fundamentally without an Ubuntu doctrine supporting it. So, and the anchoring here would contextualize in the cases like like particularly the one of Kanyamunyi, because that comes out very, very clearly, especially the one of where Justice Mobiru actually, not the entire one, but not the entire case, but a little bit of some of those. And also the fundamental what plays out very strongly is the case of Mifumi versus Attorney General. The case of bright fights and then the communal culture, where the problem in the context as there were no heritable Ubuntu precedent that is actually created, although we know that fundamental Ubuntu was actually at play. So we see it hidden there, but not evidently invoked, perhaps using the very strong phase of that. So, excuse me, then I will argue in terms of category 3. Category 3 would be in terms of Ubuntu, how Ubuntu plays out as a deficit in terms of the cases that have actually manifested. So here we see that there is neither Ubuntu reasoning nor Ubuntu outcomes. Yes, so you look at the case like Opio versus Obote. Again, Justice Mubiru makes that proposition. So we see Ubuntu sympathy, but not procedural architecture that is prevailing in this component. So also the pre-Abuki witchcraft banishment, and then the aspect of widow succession cases, all those play out in terms of what I would argue in terms of the Ubuntu deficit cases, in terms of the dispensation of our discussion tonight. Then, so therefore, that helps me create what we call an Ubuntu divided index. Yes, and the central conception in terms of the contribution to this particular analysis would be a constitutional audit that I would probably use in terms of measuring what is gained when courts engage Ubuntu, yes, explicitly in terms of the heritable doctrine, but also what is lost, particularly in terms of category 2, when the precedent is actually, is dividend, and then what is lost in category 3 in terms of the measurable communal harm. These are fundamentals in terms of my discussion for this particular aspect. So the formula therefore would be Ubuntu, in terms of explicit Ubuntu, same as equaling the right outcome plus heritable doctrine. Then the aspect of latent Ubuntu equaling the right outcome but no doctrine. And then the Ubuntu deficit equaling neither right outcome, no doctrine, but plus measurable communal loss in terms of that context. So that's how I've narrated for you in terms of the breakdown for us in terms of that. And then perhaps also important is the aspect of the decolonization deficit as a context of Ubuntu, where we're saying Ubuntu without liberation, So this is basically how Dr. Kamumba applied his analysis in terms of his case analysis, those of you who have gone through some of his work. So the fact that the pattern is evident, for such a long time in our cases, we see all those manifestations, but the question is, Ubuntu jurisprudence in Uganda has actually been addictive rather than transformative, and that is something you may want to take away. So the prescription basically would be a self-consciously decolonizing theoretical framework for Ubuntu jurisprudence that begins with African categories, and this is where we are playing out what we're doing tonight. And then you would also want to look at the next, I'll call it a breakdown in terms of a chapter in terms of Ubuntu in South Africa and other jurisdictions, and the purpose here being that I would create a comparative constitutional evidence for Ubuntu's legal viability and critical lessons for Uganda's constitutional development. Yes, if you argue in terms of South Africa, for example, as a primary comparator, it provided for in the interim constitution, in the postambo, which expresses constitutional invocations of Ubuntu. And then it's played out in S versus Mukwanyane, where 5 justices actually invoke Ubuntu, and the aspect of death penalty becomes unconstitutional. And then Ubuntu becomes constituted as a legal value in that context. Then also, if you look at Port Elizabeth, Prosperity versus various occupiers, which was the 2004 case, it invoked Ubuntu is actually mediated property rights over dignity of occupiers, where the aspect they called for grace and compassion in terms by Justice Sachs. And then you look at Dikolo versus Mokata in terms of that was 2006, and Makoro Justice Makoro argued that public apology as Ubuntu remedy for defamation could actually work, and that was probably by Justice and also Justice Sachs also argued in terms of dignity as a communal standing in terms of that particular playout. And then you may look at the case also called Everfresh Market Virginia versus ShopRite, where Jacobo J also made that proposition that Ubuntu as the founding principle of law. So these are fundamentals in terms of the context of laying ground for as a primary comparator for purposes of South Africa as a jurisdiction. So why then was Ubuntu excluded from South Africa in terms of the final constitution? Because what happens is, come after the preamble, then the present constitution does not does not capture those fundamentals in terms of Ubuntu as a red line in terms of it being provided for in the law. But when you look at that, you may want to invoke Cesanti. Cesanti in 2025 argued that why it was not included is because it had argument in terms of definition of vagueness and justiciability concerns, but also the aspect that anxiety that Ubuntu could justify patriarchal practices against women, and then the aspect of dominance of legal constitutional templates within the drafting processes, and then the aspect of political calculation that explicitly would actually alienate minority constituencies. So those are very important aspects. Excuse me. And in terms of the lessons for Uganda, perhaps if you look at it in terms of the comparative analysis, then for lesson 1, we could argue that it could actually engage in terms of textual work, entrenchment matters, where Uganda must explicitly name Ubuntu. If it doesn't, then we shall have the same challenges that are propounded by Setanti in 2025 in terms of his challenges. And I will discuss that exhaustively, And in spite of what Sesante points out, he also makes a case why it should have been included in terms of the constitutional framework, particularly without negating it or without ignoring it for that purpose. And then the aspect of definitional precision, therefore that becomes essential. And this is premised on Mies. Mies's relational account provides that workable judicial definition. And then the third lesson could be in terms of institutionalization that requires dedicated mechanism. You may want to look at Article 159.2 C of Kenya, because that becomes a model in terms of that. And then in terms of lesson 4, for purposes of comparative analysis, where we think it's important, is judicial training becoming non-negotiable in the context of the trade Ubuntu conscious judiciary needed. So if we can do that, then that becomes fundamentally important. And then the aspect of Ubuntu as lesson number 5, that must be protected against patriarchal misuse and constitutional limits that are actually required in terms of that. So that will inform that particular chapter in terms of that takeaway. Then if you look at the next one in terms of the what would be substantive recommendations, the purpose here would be restating each research objective, obviously, and then providing structural findings, and then advancing the evidence-based recommendations for Uganda's new constitutional dispensation. And then so fundamentally we're looking at things like express constitutional incorporation of Ubuntu as a foundational value, okay? In terms of the 3 constitutional provisions, the preamble, the national value clause, and then the interpretive position in terms of the bills of rights, rather than just leaving it the way it is. And then the constitutional recognition of Ubuntu-based justice, for example, we need to recognize them fundamentally and then work on them and incorporate it directly within our law. In terms of the Matoput, for example, Bulungi 1C, we need to operationalize Article 129.1D. That's the point I'm trying to make here. And then the aspect of building a robust Ubuntu conscious judiciary. Yes, the appointment of criteria, training through judicial studies, institute traditions, in terms of building an Ubuntu precedent in terms of that. And then judicial training in terms of Ubuntu literacy, for example, the Uganda Reform Commission guidelines could actually come into place, and then community consultation in that aspect. And then the reform in terms of the legal education. Ubuntu jurisprudence becomes a core in terms of LLB, it's subjects taught at law schools, like Faculty of Law, you could name every school, Makerere, Uganda Christian University, whatever university in terms of that. And then the Ubuntu in terms of public institutions and governance also becomes a fundamental. Parliament has to have deliberate methodology in terms of civic service Ubuntu values, or even civil service Ubuntu values. And then Uganda Civil Service College, for example, could also be incorporate some of those public institutions and governance, the Ubuntu concept. And then Ubuntu and socio-economic rights also fundamentally important in terms of elevating to justiciable, grounds in communal care obligations. So those are very important. And then I could also make a case in terms of some identified areas, including Ubuntu in commercial law, Ubuntu in climate constitutionalism, and then Ubuntu in terms of digital rights. Yesterday I was just engaging with a document that I'm trying to organize in terms of Ubuntu and the blue economy, how Ubuntu should be used in terms of playing out the blue economy. We have substantive water bodies around our country, Lake Victoria, Lake Choga, name them. But how do we engage in terms of Ubuntu? How do we engage Ubuntu within those services or within those practices that happen around those water bodies in terms of bringing it for the next generation in terms of that. So those are fundamentals in terms of that. So in terms of the master cases that one would probably think through in the discussion of Ubuntu, I would argue quite a number of them because there are really many. But let me just read out cases for Uganda would be cases like Salvatore Abuki versus Attorney General, where the aspect of banishment on witchcraft was declared unconstitutional. How did this become? Why this becomes a foundational moment in terms of Ubuntu contribution? Justice Tabaro held that banishment subverts communal belonging. So the relational conditions of personhood, first, explicit invocation of Ubuntu as a constitutional value in terms of Ugandan court. Justice Tabaro was able to see beyond the person, the individual, and so the individual, not even the person, because personhood would engage the person and their community. So he was able to see the individual beyond the individual, and so the personhood that engaged this individual, although the individual had carried out an act that which was guilty, but Justice Tabar was able to know that this would occasion unfairness in terms of those other people excuse me, that heavily depended on them as a community. And also that was introduced, by the way, by Justice Langa and Makoro in our case of Mukwanyane in terms of the constitutional discourse, which I argued in category 1. So that is a very fundamental anchor case. And then you look at again Attorney General versus Salvatore Abuki, the holding in terms of the Constitutional Court that affirmed Article 24 and 44, protecting communal personhood as a conditionality. That also became fundamentally important. Yes, so those the cases that would actually play out in terms of jurisprudence are the ones that I'm emphasizing now for purposes of our discussion tonight. So, Attorney General versus Salvatore Abuki, in terms of the holding where the Constitutional Court affirmed Article 24 and 44 in terms of protection of communal personhood unconditionally. That plays out extremely very strong in terms of that as an Ubuntu element. The highest appellate endorsement of this Ubuntu analysis, Kanyihamba was the judge of the Supreme Court then, elaborated the absolute character of non-derogable rights, the Ubuntu insight that communal belonging cannot be forfeited through wrongdoing. That is really stamped for purposes of emphasis. And then if you look at Kamanyimunyi versus Uganda, you may want to look at particularly what Justice Mobiru says as a holding here, Matoput. Tradition is recognized as an Ubuntu-grounded restorative justice mechanism in formal communal sentencing. Although, as I said, he doesn't fundamentally doesn't override any other criminality in the context of other provisions that the law had set out. So if only could be resolved within the Matoput, then maybe we would argue and say, okay, that's good. Maybe it was resolved, but then we see the court again, taking on another aspect in terms of the criminal case where he actually pronounces himself in terms of the punishment in that context. And then the aspect of Opio, you look at Opio versus Obote, you may want to look again what Justice Mobiru presents in terms of the consent judgment being upheld on standard common law grounds. Justice Mobiru actually articulated Ubuntu's forward-looking judicial orientation in terms of that context. So as a contribution, I make this under category 3 in terms of the cases that I laid out. Kanyamunyi was under category 1 and 2, but particularly 2, and then Opio versus Obote becomes category 3. In terms of the anchor case, Justice Mobiru here argued that the court is not merely a tribunal for resolution of past disputes, but an institution for the construction of the community's future in terms of judicial Ubuntu sympathy that overcame by unreformed procedural architecture, and demonstrates why structural reform therefore becomes a question of importance in terms of that proposition by Justice Mubiru here. Then you look at the case of Cesar Chigula and then 14 others versus Attorney General. You may want to look at that as where a mandatory death penalty was struck as being unconstitutional. And the position here in terms of the Ubuntu contribution is that Ubuntu, reading in terms of the mandatory sentencing eliminated that judicial capacity. The aspect that the judicial officials were given that mandate or that leverage to be able to contextualize their rulings. Okay, not so in terms of whether the aspect of shall became non-mandatory in the context, because now shall was eliminated in that context. So the judicial officers are able to give what is appropriate according to how they are dealing with the minimum set, of course. So Ubuntu, in terms of that mandatory setting, eliminates judicial capacity to assess the relational human being before court. You look at Kanyihamba and also Tumwesije, just those two judges, they grounded the reasoning in individual relational humanity in terms of that. So it can fall under category 1, but also under category 2 in terms of our discussion. When you look at another case, Mifumi versus Attorney General, as a holding, it argued in terms of the compulsory refund of bride price as a struck as a material coercion. So the voluntary exchange was actually preserved, and the aspect in terms of the Ubuntu contribution here became, according to Justice Chisache, the voluntary bride price in terms of an exchange was a sharing of togetherness in the context of traditional cultural affirmations. So Ubuntu, this grounded distinction between customary solidarity and even customary subjugation. So you add that perhaps in terms of case 2 of my analysis. And then in terms of Kambadize and 20 others versus Kampala City Authority, another case that comes to mind, where the aspect here in terms of procedural technicalities cannot defeat substantive access to justice for residents facing eviction. In terms of an Ubuntu contribution, when you argue in terms of Article 126.1, it applied substance over form. So Ubuntu orientation, in others, the law exists to serve human relationships, not erect procedural barriers. So I could argue that under category 2 of analysis. And then if you look at FIDA versus Attorney General, in terms of the holding, there was an asymmetric divorce ground struck down in terms of gender equality affirmation. And the position here in terms of the contribution is that the gender Ubuntu, in terms of unequal law, corrodes communal standing of every woman. So you could argue that in terms of category 1, in terms of ground, this ground gender equality claim in rational dignity. And then you look at another case like, for example, Ara versus Amkeo. In terms of the holding, you could argue in terms of the customary marriage that was dismissed as wife purchase. The Ubuntu contribution here would be in terms of the colonial negative. The colonial negative that played out. It epitomizes the repugnancy doctrine, destroying Ubuntu communal values. So when you look at what Chief Justice Hamilton said, he dismissed and attacked the communal dimensions of customary marriage as a collective family participation and mutual clan solidarity obligation. It is the intellectual residue which persists on black letter legal reasoning in terms of that context, as we have probably talked about already. Then if you look at some South African cases that play out in terms of the discourse or discussion, you could look at S versus Mukwanyane, and the holding would be in terms of the death penalty becoming unconstitutional, where 5 justices actually do invoke Ubuntu, and the contribution would be in the context of creating what they call foundational cases. It becomes a foundational case, of Ubuntu constitutionalization. Look at judgment of Justice Makoro, where we're arguing that Ubuntu is communality and interdependency. When you look at Justice Langa, Langa makes that proposition that Ubuntu carries the idea of human dignity and true humanity expressed communally. When you look at Justice Sachs, Justice Sachs makes that proposition that Ubuntu envelopes group solidarity, compassion, and even respect, human dignity, and even conformity to basic norms. And he introduced the Ubuntu into constitutional vocabulary as a legal norm or as a legal value for that purpose. So those are fundamental in terms of as well the discussion in terms of South Africa. But look at also the Port Elizabeth versus municipality Port Elizabeth municipality versus various occupiers. Beg your pardon on that, where it was held that Ubuntu mediates property rights against dignity of occupiers. Courts must actually infuse the elements of grace and compassion, yes, into the formal structure of the law. And as a contributor, what could be picked out is it extended Ubuntu jurisprudence in the form of criminal justice to property and even social rights. So Ubuntu operates across all constitutional domains, not merely life and death questions. So we see it being played even in other areas of what would be understood as the law. Okay, and then we could look at Dikoko versus Makolta. You want to look at it in terms of the context of what Justice Makoro and Justice Sachs said in terms of concurrences in this. They argued in terms of they argued for public apology as Ubuntu remedy for defamation instead of financial damages, which becomes extremely also important as well. And then in terms of the contribution, it created what you call intellectual high water mark, yeah, in terms of an Ubuntu for private law jurisprudence, for example. In fact, Justice Makoro created it as a remedy. He says the remedy must restore relational fabrics, not commodity dignity. And Justice Sachs makes this proposition that dignity is actually a communal standing, not abstract entitlement. And resonates with the Matopu tradition and shows Ubuntu's capacity to reform the private law as well. So that's also very important in terms of analysis in terms of that case. When you look at another South African case, Everfresh Market versus Virginia. Everfresh Market, Virginia versus Shoprite Checkers. I beg your pardon. Everfresh Market, Virginia versus Shoprite Checkers. Look at Justice Yakobo. Justice Yakobo made that proposition that Ubuntu describes as a founding principle of law located within a constitutional framework that aligns subsidiary law in the same direction. And as a contribution in terms of what he propounded would be that most far-reaching judicial characterization of Ubuntu in terms of constitutional status, Ubuntu is elevated to the same constitutional tier as dignity, equality, and even freedom in terms of that particular playout that individual gave to us. So some of the literature that you may want to look at when you're discussing this component of Ubuntu towards a new constitutional dispensation would be things like look at people like Magobe Ramos. Magobe Ramos makes interesting judgments here in terms of a takeaway. In terms of African philosophy through Ubuntu, we look at his books in 1999, where he says Ubuntu is a cornerstone of African philosophy grounded in Bantu ontological worldview. Yeah, in terms personhood is actually construed through communal relationship, not prior to it. And these are the points I'm trying to raise on last time. And Ubuntu represents an ontological departure from Cartesian individualism. Yes, Ramsey's foundational role in terms he establishes Ubuntu as a philosophy, not merely as a cultural sentiment as well. When you look at John Mbiti, another beautiful author here, in terms of African religions and philosophy, we look at his book, second edition, Heyman's 1990. He said, I am because we are, and since we are, therefore I am. Very, very popular statement. In fact, the most quoted formulation of this discussion would be premised on that. So not merely empirical observation, a normative claim about what human beings ought, most to value, and the philosophical baseline against which all judicial reasonings should be premised on. Particularly, this is captured in chapter 4 of my discussion in terms of an assessment. And then you look at Theodore Mays. Theodore Mays makes that proposition in terms of Ubuntu as a moral theory. Remember, because that informs our theoretical framework. But particularly, he argues Ubuntu's ethic, in terms of ethics, is not cultural patricianism, it's not cultural patricianism, but universal moral theory. Yes, it distinguishes three strands, for example, in terms of communal, in terms of dignity-based, in terms of rational. So the thesis adapts the relational strand as a working conception in terms of that. And May's three-strand analysis provides the philosophical foundation of the Ubuntu interpretive principle as well. So that's also very fundamental in terms of the discussion. When you look at Dr. Kabumba Businje, in terms of his argument, in terms of the trap of the black letter law in Uganda in 2019, the most important, perhaps, Ugandan source in terms of this argument that I'm propounding this evening, the black letter positively is a colonial inheritance that that treats formally enacted rules as the exclusive source of legal authority, excluding indigenous values from actually judicial reasoning. So these three structural obstacles to decolonization, number one, in terms of dominance of politism in legal education, which is very strong in terms of our country, institutional conservatism of the bench, which is very strong, and then the absence of theoretical framework for African jurisprudence, which is also for. So the thesis that I'm propounding tonight gives us that mandate as in terms of supplying what Dr. Kabumba says is missing in terms of that analysis. So, and then you want to look at Filawekisi Sesanti. Filawekisi Sesanti is a guy who actually talked about why Ubuntu was actually not captured in the present constitution of South Africa, I think 1996, rather than because it was captured in the preamble, but then the constitution, it kind of disappeared. And when you look at people like Professor Magobe, they also make that proposition and they actually give reasons why. But Sesanti puts it in writing. And the most recent and rigorous analysis in terms of how he said why Ubuntu was actually excluded from South Africa's final constitution. And he makes the argument that it had to be with political calculation, and then the aspect of consequences, and then the aspects of jurisprudential asymmetry. So Ubuntu functions when judges choose to invoke it, not as a constitutional mandate. And the lessons for Uganda, explicit textual entrenchment is actually required, because we don't want to face the same problem that South Africa is facing as of today, because of those things that I just pointed out. And then when you look at the aspect of Justice Makoro, again, in terms of Ubuntu and the law of South Africa, his paper of 1998, yeah, Ubuntu is not easily definable in the ordinary sense, and I think that's a beautiful terminology. He makes a very strong, beautiful wording. He says Ubuntu is not that you see, recognize, but you can't know it. You can't name it, perhaps. You can't touch it. It's there. You feel it. You like it. It's serious. So its meaning is actually construed through living experience. Yes, the Constitutional Court gave Ubuntu its most comprehensive philosophical treatment in this case of Mukonyane, by the way, and her formulation of Ubuntu as culture that expresses itself in our inclination not to act in the interest of community established Ubuntu as a living principle, and that's what her lordship presented in terms of that Justice Makoro, in terms of that component. And then if you look at Kwame Geche also makes a proposition in terms of tradition and modernity. If you look at his argument in 1997, he restricted, in terms of what they call restricted communitarism. Yeah, communitarism in terms of African societies that maintain a distinctive balance between personal authority or autonomy for that purpose and collective responsibility. In fact, the argument is that Ubuntu does not eliminate the individual in it. It insists on communal obligations while preserving individual moral agency. So the philosophical model must closely be aligned with the thesis account in terms of Ubuntu operating within a rigid-based constitutional order. When you look at people like Professor Sylvia Tamale in terms of decolonization and Afropenism, you look at that in 2020, you want to argue that the reclamation in terms of indigenous jurisprudential traditions requires rethinking what counts as authoritative legal knowledge. So critical would be in the sense that Ubuntu's potential misuse as ideological cover for patriarchal cultural practices should actually be looked at with a critical eye. So the study becomes a critical assessment in terms of my analysis, particularly chapter 4, in light of that. And then when you look at people like T.W. Barnett in terms of Ubuntu as an African equity, you might argue in 2011, their argument is that Ubuntu performs in African legal thought the same humanizing factor that equity performs in English common law. There's a similarity. So contextualizing this rigid rule application by reference to communal values, for example. So the characterization illuminates Ubuntu's constitutional potential as a principle that can moderate the harshness of this formal doctrine in terms of that. And then you look at people like Pius Langa again in terms of their works on transformative constitutionalism, which is 2006. It argues that constitutions must actually generate substantive moral change, yes? Not merely a formal structural rearrangement, for example. In terms of Ubuntu's insistence on the communal constitution of personhood, it keeps what they call transformative constitutionalism within the ethical depth. It needs to move beyond formal legalism. So Ubuntu and transformative constitutions are actually natural philosophical partners in terms of that composition. So those are fundamentally important things that we needed to talk about for purposes of our discussion in terms of this evening. I've tried to lay bare some of the things that are important when you're having a discussion. And now I would thank you and probably wait to go for the next discussion. But for category 3, if I go in the next 1 minute, I should be finishing. Neither Ubuntu reasoning nor Ubuntu outcome creating a communal loss, that would particularly what I argued in category 3. But in terms of my recommendations, number 1, express constitutional incorporation in terms of constitutional incorporation of Ubuntu, in terms of the preamble, in terms of the national values, in terms of the clause, and in terms of the interpretive provision. And then constitutional recognition of things like Matoput, Urenji, name them in terms of an Ubuntu-based, justice mechanism. And then the aspect of Ubuntu conscious judiciary, appointment, criteria, judicial studies institute training, they should be given that information and harnessed in such a way that they can use it, And then the Law Reform Commission, in terms of guidelines on Ubuntu jurisprudence, they could come out with substantive work pieces and then policy frameworks that we could use to adapt. And then, of course, together with the reform of the legal education in terms of the core subjects that are taught in law school, call them whatever law schools they have in this country. So as a takeaway, I would argue that a new constitutional dispensation for Uganda is one that actually expressly incorporates Ubuntu as a foundational value, as a foundational, and recognizing this Ubuntu-based justice mechanism. It trains an Ubuntu conscious judiciary and reform this legal education. So it would be better equipped to meet the challenges of post-conflict recovery, for example, governance legitimacy, and even ethnic cohesion, that a framework that continues to rely solely on imported liberal constitutional models it should be done away with. So this is not a claim about replacing Uganda's constitutional order. It's a claim about completing it, recovering what the colonial legal order suppressed, and activating what the 1993 Constitution already contains in latent form, and building the institutional conditions in which Ubuntu's judicial potential can actually live and be fully realized. So the Constitution, as we speak today, the 1993 Constitution, should be given that concept of Ubuntu divided index that has measured the cost of not following it, because we know from time to time it's very important that we need to follow it. So it's very important, my friends, to have a simple, fundamental analysis in terms of what we need to take away for purposes of this beautiful subject Ubuntu, in terms of Ubuntu being humanity and the law, what our Ugandan colleagues will call Ubuntu Bulamu and the law. Maybe you want to look at it as an extraterritorial interpretation too, in terms of that. So thank you very much. We come and we shall have another discussion later. Thank you.